Okay, now we are.
All right, calling to order the Board of Commissioners in our County Council public meeting. We have all three commissioners in the room. It's August 16th at 1:30. Start with minutes from our August 2nd meeting. How do those look to the board?
Good.
They look good.
Then those would stand approved, and then we go into camping ordinance. Got your email, look great.
Good, thank you. So yeah, I sent around an email yesterday with the most recent version of our draft camping and ordinance. So that's the code portion, and then also policy, which is a little more specific, but complies with Oregon statute as to any policies cities and counties must adopt and the provisions for which they must deal with homeless persons and homeless persons' property. As I'd mentioned in the email, I attended the AOC County Council's conference this summer, and we spent an hour talking about this, and only 2 of the 36 counties have actually adopted a code provision. And that's Washington, which I sent you, and Deschutes, which I sent you as well. And they are two very different codes. Washington County is very, I mean, they still comply with the Boise case and the Grants Pass case, but they are much more, I guess, open to camping. They take a much stronger look at if other sites are available. They have, I believe, a acre or something of camping area within their county. Jackson County Council spoke quite a bit about how much different we are on the east side and the rural counties, because if they are up in they were maybe Shady Cove they were talking about and enforcing this, alternate shelter doesn't exist up there, and so someone who's homeless, most likely not with a vehicle that can get them back, we would have the same issue with blind. Was my thought. And our,
Right.
or Chiloquin or Lapine or, I mean, all of our different areas, not Lapine all the way, but Crescent, Hillcrest. So Deschutes County seems to take the time, manner, and place, time, and manner requirements and pretty much prohibit any overnight camping on any areas not so designated. So dusk to dawn approach is how theirs is written. And we've kicked that around before, keeping public safety in mind, keeping that it's not open to the public 24 hours. And so that's another provision of the statute is speaking to areas open to the public. They regulate parking areas much like we already do. No overnight parking in our parking lots or camping in our parking lots. And given your meeting yesterday, where our one overnight campground is now a day use, all our parks are now day use. I tend to take the position that in our code, our campground regulations are separate from our regular public space regulations. And so I don't know that we're required to create a code. I know from the law enforcement perspective, it'd be much easier for them to have something to point to. I raised in my email the question of what if they refuse to leave after a 72-hour notice, or say they're in a public right of way and they're causing a danger, or they're impeding ingress and egress and violating ADA law. What do we do? And maybe we go down to other portions of our code where we can, after 72 hours notice, or if it's an emergent circumstance, point to another portion of our code that's they're either causing a nuisance or I don't know that our code has any trespass, but I don't know why our deputies couldn't just cite state statute in regards to trespass or something of that nature. So
Well, they would have to cite for that specific code that was the violation, which would be our unlawful camping
Right,
ordinance.
so we'd have to go back to our code and our civil fine procedures.
Right, so there needs to be penalties associated with any type of ordinance we.
And we could name it as one of the classes of penalties that
Sure,
we have.
sure. But that would have to be in there as well, because that specific code would be the violation.
Right, and what we absolutely have to avoid is penalizing someone for the status of being homeless.
Right.
That's not what the citations and the violations can be for. So they would have to be blocking the roadway or blocking the right of way.
Or camping
During
where
where
it's
it's not
prohibited
allowed.
hours.
Yep, absolutely.
So you're not punishing camping, but you're punishing time, manner, but you're enforcing time, manner, and place.
It seems to me how it have to be written.
Agreed.
You know, and it's, we're kind of playing in an area of, well, you know, is Deschutes County gonna be a test case, or would Klamath County, if we had something like that, be a test case? I don't know.
Well, how many test cases have there been regarding time, place, and manner on homelessness?
Well, and that's the interesting part is Grants Pass, and that's why they're stringently appealing it. I imagine all these cases eventually will work their way up to the Supreme Court because they're so important, but Grants Pass, what they really came down on them for was the penalty of the fines.
Mhm.
And they called them a civil fine, and they went back to where, well, civil or criminal is, you're still punishing.
Still.
And it went off on a little bit of a tangent because they made available one park and said, go camp in this park. But that didn't satisfy the plaintiffs. So I don't know. I mean, those are the cases that we have to look at. I don't know if any others as we speak. And so basically, all we have to go on is what the case law reads and hope we get that right. And, you know, the Boise case specifically says, we're not saying that someone can camp all the time, anytime, anywhere they want. That's not what we're saying, and that's where they said time, place, and manner. That we still have the ability for public safety purposes and for, you know, just the betterment of the community to be able to regulate public spaces.
Yeah, and I just really don't see it as any different than our parks. If we say you can't be in the parks during certain hours, it's public property and we're regulating time, place, and manner in our parks. And to expand that to all public space, but it be a reversed time, place, and manner, what I mean by reversed is you're saying, go ahead and camp. Camp all you want. But you can only do it between 8 p.m. and 5 or 6 a.m.
And I don't think we're saying camp in a sense, because we don't want erection of structures and.
Right.
And we still wanna prohibit digging and.
Somebody can have a sleeping bag and lay in the park and sleep,
And the rudimentary
right?
means of keeping
Right.
warm, yep.
Somebody can put a tent up. Why not? It's just, if it's shorter or smaller than, you know, a
Yeah.
certain.
See, from my perspective, I would say that rudimentary forms of keeping warm and shelter didn't include tents in the Grants Pass case. But I just would say that the construction or the erection of any kind of shelter, to me, I would hope to keep prohibited, because once you get there,
I agree with that.
fires, campfires
Right.
should be prohibited.
Well, I think we can fall back on when the US Forest Service says we're in no burning and we're in no campfires, we just make that county policy. So I think there's a way to do that as well.
Another issue to your point is most of our open spaces are county parks. You know, the other open spaces we're speaking of are sidewalks and right-of-ways. I don't know of other large areas that the county has. Obviously foreclosed homes are gonna be prohibited at all times. Those aren't open to the public.
Right.
You know, or any foreclosed properties or any other properties that are restricted access. We've got a lot of those.
We're really
Areas.
talking about right-of-ways, easements, things like that.
I believe so, because our parks are our parks, and
Right.
we're gonna regulate them dawn to dusk
Right.
anyway.
It's already regulated, correct.
And so what's the what's the code, if you wanna go the route of the code beyond what the county policy, which follows the state statute. And some counties are doing that, they're just saying, we're just gonna go with the state statute and give people 20 to 72 hour notice, and we're gonna start removing property.
And we could, you know what that means? What he just
Which
said, the
part?
state statute on the 72 hour, basically it's an eviction notice, 72 hours, that's probably the best way to
Yeah,
put it,
and
right?
I just
You're in a
realized I
place-
forgot to stick it in that email, I meant to have it down there for you guys for a quick reference, but I can pull it up. But yeah, it's very much, gives the direction, and it's the policy all municipalities and counties have to adopt in order to comply with the state statute, of how to deal with individuals and their property.
That's been around for quite some time.
What is the next step? Is it having the ordinance hearing?
Well,
If you won't even move forward with an ordinance,
Mhm.
you can simply just land on state statute and call it a day. I don't think there's enough to it, in my opinion, because somebody could pitch a tent. Downtown's not our problem, because it's Clamath's problem, but let's just say downtown. And you gotta look at that and deal with that for 72 hours.
You can just look at all of the tents that are pitched out off of Washburn Way. I mean, we have issues out there that we're not dealing with, and an ordinance could.
and I think they're taking advantage of right of ways,
Yep.
quite frankly, because they're getting on the edges of commercial properties, but they're pretty much camping on the sidewalk or in the
Mhm.
borrow pit, whatever you wanna call it. I
Yep.
don't know if you've been on the backside,
So
kind of where Walmart, that road, I can't think of the name of the road back in.
Laverne.
Laverne.
Laverne has had some pretty good camps in there.
So, and I've read what you wrote so far, and I read the Deschutes one, and I read the Washington County stuff that you sent us, and then the slide. I think ours, the draft that you presented, I don't have any edits, and I would be fine with moving towards a hearing and adoption.
My only question was sitting. How are we defining it? Because we don't define it in the.
And it's not defined in
Right,
the statute, either as lying,
right, so people are, well,
I mean,
right, and my issue is people are gonna take it at face value. So for somebody to just sit in it right away, is not what we're talking about. We're talking about camping.
Right. Even if, the way I read it, even if somebody were to just lay down without any paraphernalia
Right.
at all and just lay down and go to sleep,
Yeah.
they don't violate what
Right.
you wrote.
unless they're probably impeding,
Unless they're,
you
yeah,
know, because
because they're not
what
camping.
ultimately happened in Portland is they were not enforcing anything.
Mhm.
And someone brought an ADA claim. They couldn't get their wheelchairs down the streets of Portland, and it cost Portland millions. It was already costing them millions on the front side, right, with all this stuff in there, and then it cost them on the backside. So we wanna make sure that we comply with ADA as well.
I had to watch my steps so I didn't step in human feces.
Well, I'd be interested in moving forward and closely resembling Deschutes County, and I say that because we're on the highway with Deschutes County. We get a lot of visitors that are just coming up and down 97, so being somewhat consistent in that messaging and the I wanna make sure I say that the right way.
But when you drive 97 north to south, it looks the
Yeah.
same.
Yeah.
It looks similar.
Let's go.
Well, and
Yeah, I'm good with moving forward too.
do we want to add some form of penalties?
You have to, otherwise what's the?
Right.
Right, you're just saying, don't do it, but if you do, meh.
Well, and that's how I've felt about other counties / municipalities. Codes that say we don't want you camping, but if you do camp, and then they tell them how to do it, and seems to me to be the wrong message.
What kind of penalties would we be talking about?
I'd have to go in the code. The major penalties are $720, but that might be a little extreme.
Yeah, and again, it's not a penalty for camping. It's a penalty for not acting, not engaging in that behavior in a specific time, manner, and place when that behavior is acceptable. And to just have a silly example, freedom of speech and freedom of expression and protest is lawful. It's constitutionally protected. But you can't do it if you're interfering with another lawful assembly. So we still dictate time, manner, and place for all types of constitutional rights. Does that make sense? So even though the court has said camping is not unlawful, you're right, it's not. Visiting a park is not unlawful, but you have to do it in the manner in which that municipality or that government deems to be acceptable.
Even a more fine-tuned approach to that is they say that being homeless is not unlawful.
Right. That's not.
And
Being
so
poor
that's-
is not unlawful.
So
Being rich is
camping
not
can be
unlawful.
unlawful.
Right.
But it's the status of being homeless. And what they tied it to, and I may have gotten into this with you guys before, was there was a case from the South and a guy was penalized for being a drunk or an addict. And there was a law against being an addict. And the idea was well, this is an illness that this person can't help. And so if they can't help it, they can't be criminalized for it.
But we say you can't smoke in buildings. Smoking is legal, but you can't do it here.
I personally believe that the Ninth Circuit made a stretch with it. And took it a different way, as opposed to taking away property rights of property owners. But that is what it is, so yeah, we have to work around it. So yeah, it would be something to that effect, but essentially misusing the county property is what the
That might
violation
even be
would
what
be.
you title it,
Misuse of.
misuse of public lands.
Okay,
Cool.
so I will get you all another draft.
All right.
Let's get it
well,
right.
Anything else? We can do any other business, and then we have the dog hearings, which are a time certain of 2:00. Then we will recess till 2 p.m.